Hey, good morning, everybody. My name is Chris LeGras. I'm a lawyer and volunteer bill analyst with Livable California. And it's not often that a lawsuit is cause for celebration, but here we be. This lawsuit was filed, I guess, just a couple of weeks ago. And what I want to do is explain the legal framework really briefly, um, quick rundown of what is in the lawsuit, and then some of the open questions that it raises. So SB 9, among its many flaws and problems, is it turns a traditional premise of urban planning and even our built environments in general, it turns it on its head. Different aspects traditionally, and this goes back in a lot of ways, I mean, even pre-United States, back to almost like Magna Carta, different aspects of communities are subject to different types of legal regimes. And depending on what we're talking about, the level of government that has primary responsibility is different. So for example, streets and roads. Streets and roads are traditionally considered a matter of statewide concern and statewide control. And the idea being that streets and roads, by definition, connect different cities with their own legal protocols, their own rules, their own traditions, etc. And you need some state level commonality and consistency on the roads. So for example, there was a case maybe 20 years ago in the early 90s, gosh, 30 years ago now, I'm showing my age, that was called City of Long Beach versus City of Hawaiian Gardens. And in that case, the city of Long Beach had tried to close part of a road that ran between and ran through the two cities. And the California Court of Appeal held that the city of Long Beach did not have the authority to do that because it adversely affected traffic, public safety, emergency response, et cetera, in the adjoining community. So that's a good example of where state level authority is longstanding and accepted. In contrast, when it comes to development, zoning, and planning, those are traditionally local and municipal concerns. And it's for the kind of exact opposite reason, in that local conditions, local knowledge, et cetera, is not just important, but indispensable when it comes to planning and zoning decisions, because local government knows, for example, where the fire zone is, even when it doesn't necessarily appear on a map. It knows the history of the various neighborhoods and within their jurisdiction and what's best. SB 9 turns that completely upside down. It gives cities now control, not necessarily over roads, but over parking. We'll get into that in a minute. But more importantly, it essentially removes local control over certain types of development proposals. And just, I'm sure you all know, but by very quick way of review, under SB 9, which is now, of course, part of the government code, any landowner can subdivide a single family. And by the way, quick aside, and this is editorializing for a minute, I think we should all stop using the term single family and start using the term detached, because in many, many communities, a detached home, multiple generations, sometimes family, friends, et cetera, are living in that same detached home. So because a lot of us are here, I just want to put that little bit of editorializing out there. So anybody who owns a detached parcel, single family parcel, can by right subdivide it in half, so long as the subdivision, the resultant subdivision, meets certain criteria. Neither parcel can be smaller than 1,200 square feet. Neither parcel can be smaller than 40% of the previous single parcel, and it must be in an urbanized area, which is another issue we'll get to in a second, and that's defined by the census. So long as it meets those three pretty easy to meet requirements, and excuse me, it also, urbanized area, we said that. The subdivision goes through, and unless the jurisdiction, unless the city makes, and I'm going to read this language, finding of a specific adverse impact defined as a significant, quantifiable, direct, and unavoidable impact based on objective, identified, written public health or safety standards, policies, or conditions. So again, we're turning convention upside down in that we're putting the burden on the city to make these really and that's for one development, by the way. Now imagine if you got 100 of these or 1,000 of these applications in your community. And just to deny one, you have to go through all of those hoops. So for all intents and purposes, it just bulldozes, pun intended, local control. Now, what this lawsuit is about, this is what's called a petition for writ of mandate. And it's slightly different than a normal complaint in that they're not seeking damages, they're not seeking money. What they're seeking is the court essentially to order that the state of California, and HCD specifically, do what the existing law tells them to do. And by existing law, in this case, we mean the California Constitution. So as we were saying a minute ago, development, zoning, planning decisions are matters of local control, and that's actually enshrined in the California Constitution. And just 10 years ago, and this shows you how rapidly things have changed in Sacramento, in 2002, in a case called State Building and Construction Trades of California, AFL-CIO, versus City of Vista, the California Supreme Court reiterated, charter cities are specifically authorized by our state constitution to govern themselves, free of state legislative intrusion, as to those matters deemed municipal affairs. And going back again more than 100 years, planning, zoning, and development is a matter of local control. So that's the framework for this lawsuit. And one thing as a litigator, it's always a good sign when your case, when your petition or your complaint is actually simpler than the subject matter that you're attacking. This lawsuit is as straightforward, and by simple, I don't mean simplistic, don't get me wrong, but this petition as written is as simple and straightforward and clear. You don't even necessarily need a legal background to understand it. That bodes well for this lawsuit because it is as straightforward as SB 9 is complex and convoluted. So the crux of this case is really twofold. Number one is the attack on the traditionally constitutionally protected right of cities to determine their own destiny when it comes to development and zoning. The other is that SB 9, now this is Christopher's editorializing, it almost kind of has its own poison pill, and it's an inadvertent one, and Paul and Stu may have a different take on it. But one of the things that's really key, and I think really smart in the way they drafted this writ, is that SB 9, the way the legislature ripped this one aspect of local control out of localities is by saying this is a matter of statewide concern. Well, this being what? This being affordable housing. We have an affordable housing crisis. It's everywhere in the state. You stupid cities have had long enough time to go to Sacramento for affordable housing. But then SB 9 turns around and has zero affordable housing requirements. Well, you said it's a matter of statewide concern because we don't have affordable housing. Then you wrote a law that's going to result in tons new market rate, above market, and luxury housing. And they nailed that, and I think that's the single strongest aspect of this case, is its own, again, I would call it like an inadvertent poison pill. So I think, and again, editorializing this petition, this case is largely going to hinge on that flaw in the bill and in the law. There are a couple of secondary, I mean, I say secondary, they're still very, very important, but from a legal standpoint, I think they're kind of like the number two arguments, and that is that SB 9 is going to have incredibly disparate impacts on different localities. If you live out in Pacoima and you're trying to hit your arena numbers, SB 9 projects are going to look very different than if you're in, let's say, Pleasanton, up in Julie Testa's neck of the woods. So there's some secondary issues related to that. There's also, and I think it's interesting, there are two actually federal, like US constitutional issues that they kind of raise, but don't put them into the actual petition because I think they're just really narrowly focused on the flaws in SB 9. And that is that there are, as I alluded to a minute ago, there are actually equal protection concerns. Different communities are going to be impacted wildly differently by SB 9. It's interesting to note that 2 of the 4 cities that are petitioners in this case, their populations are 75 to 80% non-white. And as we know, that's one of the key threats of SB 9 and all this legislation is that it is working and middle class, primarily non-white neighborhoods that bear the initial brunt of this wave of development. So again, even though it's not part of the cause of action, I think it's an incredibly important point that they raise that the court will certainly take into account. And then the other secondary issue is the due process issue. And I like this line, I'll just read it. It's in paragraph 63 of the complaint. It says that SB 9 prohibits any due process for the affected housing applicant or neighbors and closes off any public accountability of public officials. So those are two very key points that aren't, again, in the cause of action themselves. The last thing I'll mention, and then I'll turn it over to Paul and Stu for some additional background, is that when you are making a constitutional argument about a law, the court, depending on the subject matter, will apply different levels of scrutiny. So if the law looks like it's going to have a disproportionate impact on a protected class, for example, Black Americans, the court will apply what's called strict scrutiny. And basically it is the burden shifts almost entirely to, in this case, the legislature to justify this impingement on constitutional freedoms. In this case, it's called reasonable relation. The state has a lower threshold to defend SB 9 in that it simply has to show that there is some reasonable relationship between the problem, i.e. lack of affordable housing crisis, and the solution, massive impingement on centuries worth of very well settled law. Personally, when you get into a rational relation case, it's a little bit nerve-wracking for the petitioner. But in this case, because as I described before, not only is there no relation, much less a reasonable relation, the bill itself actually severs the crisis from the solution. So unlike your average reasonable relation case, I think they actually have a really strong case here. And let me just check my notes to see if I hit all the highlights. Paul, did you want to jump in? Did I blaze over anything?
I want to jump in, but I'd like to hear Stu first, if he doesn't mind, if he's around, and then because he really knows a lot about this stuff, and I'd like to hear from him first before I comment.
Stu, are you on? I don't see you. I don't think Stu is on, Paul.
Okay, all right. Well, then I'll make a few points. I agree with everything you've said as being consistent with what I read. The only difference I have is a matter of opinion. You think the primary strongest part of this complaint is the fact that SB 9 does not provide for deed restricted affordability. And I think the strongest part of the complaint is that even if it does address, even if SB 9 could be argued to impact the affordability, the law requires it to be narrowly drawn, as you stated, and it's not narrowly drawn. Right. The reason why I don't think the affordability, the fact that SB 9 doesn't provide for affordability is a little bit weaker argument, is based on what Stu has told us in meetings with small groups, that in his experience, the courts have been very reluctant to contradict a state a declaration by the legislature in a bill that that involves municipal affairs, that there's an overriding state concern. They tend to be very liberal in siding with the state. So I am thinking that the reason I feel this argument might fail is the complaint assumes that the word affordability applies to, like in the housing element law, to the very low and moderate income categories, where requires affordability and requires deed restriction. But affordability in the broad sense could, from the from their broad point of view of trickle down, and that is you build more market rate housing, you eventually reduce the price of existing housing and make housing in general more affordable. Okay, so now most of us listening know that that's pretty much hogwash, that that's not true, or that if it is true, it takes so many generations to get to that point that it doesn't do the job. But the fact is, the court, if it's going to lean real hard toward the state, might say, well, you know, that's legitimate. But where it's more likely to fail is where you get into, but yeah, okay, it's legitimate, but is it narrowly drawn? And here, what they're saying in the complaint is that it's not narrowly drawn. Because it disallows any subjective standards, which would ordinarily be considered by a city in a development proposal, like open space, preservation of trees, views, shade, greenhouse gases, parking, impacts on schools, utility connections, emergency access, the cumulative impacts of several projects within a single neighborhood. And of course, the point you raised about the lack of due process for other residents in the neighborhood. You know, they could have passed an SB 9 that provided for the same amount of units, but trusted the cities to make important subjective determinations as to when they should be excluded. But their kind of kindergarten approach of, oh, we can't trust the cities to do anything, might win the day, In fact, I think that's the strongest argument.
Well, it's a nice, it's always good when it's on your side that the only disagreement is which is the best argument.
Right.
And I think they did the due process and equal protection. I don't want to get down into the weeds into these secondary arguments, but Paul, some of the stuff you raised about these impacts on infrastructure, emergency response, schools, sewers, etc. Well, let me ask you your opinion, Paul. Does that fall into the bucket of disparate impact, or do you think that's a separate? Do we loop that into the central argument, or do you think that's kind of more a secondary equal protection disparate impact argument?
Well, no, I hadn't thought about disparate impact, but there is a disparate impact between SB 9 and other zoning districts.
Yeah.
And so that would be another argument that fits into that the fact that it's not narrowly tailored,
right,
to accomplish what it's trying to accomplish.
And we don't want to speculate, but this is just the opening salvo. Of course, petitioners can always amend. Reading a little bit into the tea leaves, I think they did go with these top two really potent arguments that we've been discussing, and then by sort of sprinkling the other constitutional issues, the due process, equal protection, disparate impact, maybe setting that up for an amended, I'm totally speculating now, but an amended complaint, or to somehow bring it up when the case actually goes to motion practice. So before
we stop this, you know a lot more about this than I do, so I'd rather you comment on it. Part of what they're asking for is preemptory relief. In other words, they want the courts to intercede before the case is finally determined, to give temporary immediate relief to stop these developments. Can you talk a little bit about that, about how quick a schedule they'd be on, what the chances of anything like that happening?
Well, so in terms of, that's three things. In terms of the mechanism, it's what's called a petition for writ of peremptory, or I'm sorry, a peremptory writ of mandate. And what that means is it's an extraordinary request for relief. And by extraordinary, I don't mean incredible and amazing. I just mean outside the normal litigation procedure under the California Code of Civil Procedure. And what a writ of mandate asks the court to do is to say, we haven't seen anything really bad happen yet, but government is doing something that government shouldn't be doing. It's violating the Constitution. It's violating this longstanding body of law. And therefore, court, the potential impacts of what's going to happen are so dramatic and irreversible. We can't wait for this to actually start. We need you to step in right now as the co-equal third branch and make a determination as to, in this case, the constitutionality, and then of course the legality of this law. So that's why it's not a typical complaint. I suppose they could have gone in on a TRO, but then you still end up falling back into the writ because you're suing a government agency. So that's why it's postured the way it is. In terms of timing, writ petitions, they tend to go in one of two very different directions. They either get resolved very quickly because the issue is so clear, because the government agency or body in question is so far out of whack that, this is an easy call. The other kind of writ petition turns into your worst nightmare because you've tried to sort of circumvent some initial discovery and the court yanks you back and you end up essentially rewriting or re-arguing your complaint almost as a standard complaint. So those are the two directions that a writ tends to go. Either the court says, you're trying to be too clever, get back here, junior, or you're absolutely right, let's do this super efficiently and get this resolved. So I wouldn't hazard a guess as to the time frame of this one. Obviously, hopefully, I personally, I hope it falls into category A, but I wouldn't hazard a guess. And then in terms of the likelihood of success, I mean, so it's reading tea leaves. I think this is a really strong complaint. I think they have, again, those two key arguments. But now we get into this is not a legal argument. Now we're just talking about the environment we're in, the era we're in, the fact that state judges are no less susceptible to pressure than the rest of us. All of those sort of all too human factors, as with any major lawsuit, come into play. So again, I think it's a really strong argument, a really strong petition. I would certainly walk into court with my head held high, but impossible to know, the outcome. Hopefully this will, regardless of what happens at the trial court, hopefully, these four cities and their city attorneys and their outside counsel are in it to win it, and they'll take this to the Court of Appeal and the California Supreme Court if necessary, because we need the California Supreme Court and possibly, even the US Supreme Court to weigh in on this, because SB 9 is, as we well know, is just the tip of the iceberg. And the judiciary has been pretty silent thus far. There have been a couple of small Superior Court cases. I think I saw somebody alluded to the snowball development over in the West Hills and the northeast part of LA. But hopefully this case will be the one that goes the distance, because this stuff does need to get up to the Supreme Court, and the Supremes do need to make that determination. And knock on wood, they'll follow the Constitution and not the trendy legal theories of the day.
Chris, can I ask what we're looking at in terms of timing? As the judicial process tends to be rather slow. Do we think we're looking at a year, 2 years for the first ruling?
Again, I don't think it would be a year or 2 years. The first ruling, I don't know if they've scheduled, this was filed when, just 3/29. So they'll have their preliminary hearing presumably in the next couple of weeks. And as I said, you can go in, and in that first hearing, the court could issue an order. It could be that quick. But again, not knowing the judge that this is in front of, I don't know if it's been assigned yet. I wouldn't hazard a guess on that, but it could happen quickly. Again, best case scenario, it could happen quick, and then the state is in the position of having to decide whether to appeal and go run it up the ladder. But again, regardless of what happens in the trial court, I would suspect, and I sincerely hope, that this does go all the way up. And in that case, when we go to Court of Appeal, we go to the Supreme Court, then you're talking at least a couple, 3 years.
Thank you. Okay, guys, I think that was a really good rundown. Thanks a lot. Chris has been working to get actually one of the one of the attorneys that filed the lawsuit for those 4 cities to join us in one of our calls. And so maybe in the near future, we'll get an update from the attorneys that are actually working the case itself.
Yeah, and just to interject there real quick, they actually did want to join us this weekend. The lead counsel, it's her daughter's 18th birthday today. So I said, well, I guess you don't have to come to Livable, California.
Okay.